Good morning, sir. Yes, sir. Good morning, sir.
Afternoon.
Yes, sir. Good
Yeah.
afternoon. Yes. I'm audible to you?
Yes, yes, you are audible to me.
Okay.
Namaskar, Hathi
Welcome,
Sahib.
welcome,
Hathi Sahib,
sir.
namaskar.
Welcome, sir. Welcome, sir.
Thank you, thank
Good
Okay.
you.
afternoon,
Thank
sir.
you. Good
Yes.
afternoon.
Good afternoon.
So, Rahul, you can start.
Okay, sir. A very good afternoon to one and all present here. Today, I, Rahul Randotia, Assistant Professor of Law, on behalf of Center for Legal Studies, Geeta Rattan International Business School, welcome our esteemed guest, Dr. Tapan Mohanty, sir, Professor of Sociology of Law, Social Legal Studies at National Law Institute, Bhopal.
It's not audible.
I think Rahul has some problem. Okay. Uh, okay. I'll take it like this. Professor Mohanty is a renowned professor of sociology of law at National Law Institute, University, Lucknow, Bhopal. And we are very privileged to have him for this session. So I request Professor Mohanty to begin the session. Thank you.
Thank you, Professor Hathi, and thank you very much, Rahul, for taking the pain to invite me to this session. It is indeed a very privilege that when one of your students works in a prestigious institution and you are invited to share your experience with the students, and the topic that he has given to me is also very thematic, very interesting topic, which is said evaluation of law. Now, I would take this session to deal with some of the issues or vexing issues concerned as evolution of law. But before that, you would need to know that my understanding of law that begins, or you will go through the definition of law, what it actually is. In today's India, if you think if there is a problem, most of the time we see that okay, bring a particular law. If Nirav Modi goes out, so he said, look, we do not have a law that, or Vijay Mallya goes out, we think we do not have strong laws to keep them here. If there is a pandemic on, we think we don't have a health law to deal with that. So we think many a times if our problems to the contemporary society, the contemporary problems can have a solution in the law. But mind you, that if law would have been a solution to all our problems, then there would not have been any problem in the world. Unfortunately, this is not so simple. But the other point is that if we are also able to share, discuss, debate, dialogue without fear for our life or privileges, then it's also because of law. Though India is an over-legislated country, but there are the presence of laws only make us uh, more suitable, more comfortable. Because law, as it said, is something which is mightier than the king and saves the less favorable from the mighty rapaciousness of a state or individual or a monarch. So that is why the presence of law is very, very important. In fact, when you are celebrating the idea of democracy, you also need to know that a reason of the one of the feature of democracy is, of course, the rule of law. And now, as you will study the constitutional law, you will get to know about the basic structure that the Indian Supreme Court has developed, and there also you will find uh, that they develop the doctrine of basic structure, where they talk about rule of law as an essential and fundamental feature of uh, constitution. So in that sense, the law is everywhere and omnipotent as a force. And as a sociologist, I often look at the evolution of law, the presence of law, development of law as a feature of a modernized society. So the evolution of societies from a mechanical to, as Durkheim would say, from mechanical to organic, or as you say, pre-modern to a modern, or from a theological to a scientific stage, is also marked by the equally development of a law. So if you study your concept of law by H.L.A. Hart, so you will also find it talk about the movement of law from primary rules to secondary rules. So it's a process of evolution. And you keep it in mind that when I think of describing for you the idea of a law, I have in mind that certain rules, certain principles, certain ethics that we as individuals, we are members of a group, need to follow, and in order to ensure our safety and security. It is in this context that I would share these ideas, and I think I would describe this in terms of some of my the slides that will follow, and look at it. That is how relevant they will be, and how should they help us in understanding the dimension of social, right? In understanding current problem and the futures. So it is in this context that we need to see it. We need to examine it, and we need to analyze them. Right. So let's see what is this evolution and how we can explain the notion of evolution of law today. That's what I have in mind, and I want to share with you these ideas, these values, these concepts. And yes, I'm sharing the screen. I hope you will be able to look at them. I think you will be able to look at them and then see how best we are placed to look at it. Right. So the first slide that I would say it's beginning with what is this called as evolution of law and analysis. No, I am trying to make your analysis, give an example that how this is happening. So first and foremost, if you think where did the law come from, how it is today, but always keep it in mind a very fundamental definition of law, which says that law is about a set of rules and regulations, right? That a society creates to follow it out. Sociologists have no problem with law because they always concern more with norms. But as a student of law, you need to know what is the definition or meaning of law. I would share with you two essential definitions of law that you keep it in mind so that there is no hesitation to having a handy definition of a concept of law. The first one is given by a jurist called Dean Roscoe Pound, who was the dean of Harvard Law School and very authoritative figure on law, published books on jurisprudence, and one of his contributions, significant contributions, has been sociological jurisprudence. And Pound writes, and I quote, said law is a mechanism of conflict resolution between competing parties with conflicting interests. So that means wherever there is a conflict between two parties, so we develop law as a means to resolve a conflict. So in a sense, it is a conflict resolution process. And if you are a student of sociology, then you would get to know why resolving the conflict is essential for the very survival of the society itself. Right. The second definition of law that I would share with you is one of colleague of Sir H.L.A. Hart and writer of a very important book called Morality of Laws, and that is Professor Fuller, Lon Fuller. And Fuller says law is an enterprise. Law is an enterprise right, of subjecting human conduct to the governance of rules. So he said we need to share, we need to look at it law as what? Law as an enterprise. The moment you say enterprise, then you look at the human effort. Towards what? Towards subjecting human conduct. The way people are acting in a given society. So you look at the conduct to the governance of rules. So everybody, all of us, we act. Whether we act, when we act in accordance with the rules, in following the rules, that is what is called law. And that is the definition of law. And how this definition of law has emerged, where the law has come from. So to look at them, we need to go back some more slides to see that. So first of this slide that we talk about is in that sense, is talk about this history of law, where it has come from. Early history of law. It is developed thousands of years. So first known of written law, if you think of it, you find in civilization of Misr and Egypt, which is called about the Code of Hammurabi. So it's the first set of when Hammurabi is king of Babylon and measure 2005 and 2000 BC. So 2000 years ago exactly, because we are now 2000. So 2000 years ago, sometimes we are 4000 years ago. In fact, there was the first known understanding of law, written law in Hammurabi. Then we look at different type of laws, cause unique laws to control, guide, derived from gods, directed from Hammurabi, and dealt with what is as concept of law. I will explain some of them as and when we are moving into. And say in the history of law, we look at administrative laws, domestic to look at conflict, criminal conflict. So laws directed towards children, the different types of laws, because it's not about one aspect, but it talks about various issues, how a state will administer, how will administer our domestic affairs, whether there is a crime, how a crime need to be approached, need to be children, need to be women, so different types. Then you look at an Egyptian law, which talk about the society. So we talk about then, Egypt has the kings which called pharaohs, and pharaohs were called the gods and the descendant of gods. And it is not a new, in fact, many other societies also are the same, which considered king as a descendant of gods, and therefore their word was law. And the most uh, open description about the king as a god and god of laws was by the Louis XIV, who said, I am the state and therefore I am the law. So whatever I will say, that will be law. No, of course, the Egypt also the first developed the court system many years ago. So many thousand years ago to look at it. Then you look at the ancient laws. People say where it come from. They said it came from the gods, and then gods restored the power of the ruler to make laws. And I would say you keep it in mind that in fact one of the book written by an early historian or anthropologist, Sir Henry Maine, whose book's name is actually called Ancient Laws. I'll come back to that. But initially, when you think of where the law comes from, they say laws come from God. And people define called divine law. They are called as divine law. The God that came from the God. And then the God, who will administer them? They say, okay, if the God has, the Lord or God has given law, then there must be better a superior person who will administer them, and they become the ruler. And ruler was given some power to make or amend certain laws. Then there are the religions which are about, where it is in the ancient laws. So religious influence, and the debate between church versus state, who will be more important? The church, which talk about religious laws, or the state, which is administering the people. And then the influence different beliefs, so Hebrew, Islamic, Hinduism. There are many belief systems which talk about the law. Now, this is what I begin to my side. So said, I consider as an Indian that the first set of law that we can think of in entire human society, because we have a 10,000 years of history, and with 10,000 years history means that many point of time the law itself has evolved from this tradition, and therefore the writing dharma eva hatohanti dharma rakshati rakshita. So it is look at the idea of righteousness, because it is not religion, it is righteousness, it is ethics, this principle that you have to be always kept safe by dharma. So if you are following dharma, then you are safe. Whatever you to do, so you have to follow your dharma, and dharma will always save you from all untoward incidents. And that is what dharma is. It is beginning of the understanding of the concept of law. I would not take much time in discussing that, because I will following that. Because when you want to say source, because how do you know where the law come from? If you want to know where the law come from, how we are, then you know how we create law. What are the sources of law? So if you will study later, maybe common law, some other subject, some teacher will take time to explain to you that what are the sources. So first source of law we can think of is the religion, from philosophy, from morality. Now this is what I was discussing earlier. This is what I was discussing earlier. Whether it is Greek philosophy, whether it is Islamic religion, whether it is Judaism, Christianity, or Hinduism, this is first source of law that we can think of, but developed from religions. Then came the source of constitution that people developed. Then came the idea of legislation that we are now looking at law. Then there is something called precedent, which you would law in common law, the judge made law, when judges are making law. And then there are international laws, international norms, which are becoming the sources of law. Now, if you look at the sources of law, then you would also know the evolution of law. How our laws have evolved from religion, philosophy, morality, constitution, legislation, precedent, or international norms today. These are the way laws have evolved. Like many years ago, it was actually the English biologist who is called who developed, Darwin, to talk about evolution, and he said, what you find today, it is not this form. It has evolved over a period of time. That means there has been sufficient development from a one. Like we find the evolution of human species from a unicellular amoeba to the multicellular people, dinosaurs or crocodiles or human beings. So there has been development, that has been a evolution process, a slow, gradual process of growth. So similarly with the law. Now that is what I said, from celestial to prince. The first set of law came, as I say, religions. So it came from the charismatic revelation. Now, when I say charismatic revelation, I will explain why they also are the charismatic revelation. Because these is people who we attributed divinity in them, and we believe our laws evolved from them. For instance, the Christians call the biblical religion because it has come from the teachings of Jesus Christ. For Muslims, they said it is our law is Sharia law because it has come from the mouth of the of the Messiah from the Muhammad. So Prophet. So Prophet has given us. So that is why it is sacred. That is why it is spiritual. That is that is why it is revered. And for us, Hindus, it call, yes, most laws came from the God. In fact, like we quote Bhagavad Gita, it said it is a revelation from the God to the human, from Krishna to Arjuna. The idea of what should one do, what is one's dharma, what is one's ethics, morality, what is one's values. So it's a question of development of law, beginning, which is intrinsically associated with the notion of religion. Then came about morality and ethics. Then it was not God, but people, those were wise men. And the first set of law that anywhere in the world can have or could have given by a gentleman called Manu. And that is why his work is called Manusmriti. So Manusmriti is about morality and ethics. He talked about what, because he first defined what is law, what is, we call it is what is called Niti and Rita. So this is called cosmic law, the cosmology, cosmic law, and human law. So why you look at the ethics, what a man should do on these situations. So he was the ancient lawgiver, the Manu, believing with Manusmriti. What is a crime? What is a punishment? What type of punishment should be given? What is sacred? What is profane? All these divisions are made by Manu in his Manusmriti. And therefore, and these people who are the carried forward that device by Yajnavalkya, right? Yajnavalkya. So there are many other people, Vasishtha, Narada. So who are all Bhashyakars, what is called as commentators, are taken into the text of understanding the law and explaining the law. And many of these laws are part of what is called as morality and ethics. Like we have also find Chanakya's ethics. So you talk about what one should follow, what one should do, what is the values. So these are the ideas of morality. Then, of course, we find the wisdom from the ancient Greece. Now, the Aristotelian notions of law, logic, that what we should do. And Aristotle talks about even compensatory the schemes, which he talk about that maintaining the equality in society. And he talk about uh, different type of justice and the work and notion of justice. I don't want even to Aristotle. In fact, I am reminded of a very nice or first set of drama by the greatest one of the Greek authors, early Greek authors, the ancient Greek authors was Sophocles. And Sophocles has a drama which is called Antigone, as a woman-centric character. And there in Antigone, before in a play of Antigone, Sophocles talks about through the interpretation that why he is finding the law made by the God and law made by the heaven. When his brother lay dead, and king said he cannot be buried because he has fought against the king. Therefore, the rule of the land says he is to be left there, but the rule of the God says a man is entitled to have a decent burial. So there is a divine law under the human law. And Antigone brings that beautiful conflict to the drama. And I want all of you, may, if not read the main text, but at least its interpretation and its understanding, which will give you an insight into how the divine law and human law came together. Right. And then, of course, from the Greek times, we look at canonical biblical interpretations. We find how the uh, the Western world was influenced by the religious ideas of Jesus Christ and looked at the law from the Bible, New Testament and Old Testament, how they are interpreting and how they're developing, right? What is their issues and how they need to be understood and explained. That is. Then we find the beginning of law in 13th century from Saint Thomas Aquinas, a great, no, he was a priest too, but a great thinker, a philosopher of his time, who was talked about slightly developing the principles of law from the Bible and talk about notion of justice, notion of fairness, notion of equity. Like Aristotle talk about uh, compensatory discrimination and things like that. And then we have developed to the Anglo-Saxon jurisprudence, primarily from because Thomas Aquinas was Italian, like so. How this say the British and Roman jurisprudence developed, and to give us an insight into what we call today as the modern law. So that is the evolutionary process, what is called from celestial, from the divine to the prince to the human. So journeying from divinity to humanity is a evolutionary process of law. Now, if I just again as a student of sociology and anthropology, when I look at law, I think even if you look at evolution, what type of evolution is it? And they said further law has come from culture. There is a branch of knowledge which said law has developed from culture, right? And as evolution from culture. Now, when I say culture, what does that mean? They said there are many societies who may not have the law as Anglo-Saxon jurisprudence defines it, but there are societies which effectively knew how to administer themselves. They had the norms, they had the morality, they had the ethics. So they like they had this somebody, a traditionally patriarch whom they had gone to ask questions when they're in conflict or when they're in confusion. So their knowledge that they become from law has developed from those traditional norms to what we call today from norms to law. Some people say if law is developed at one place, then gradually it is diffused to other places, because it has moved from one place to another. As people get to know about it, they find, for example, if you look at in India, we had the concept of law, what we have found in like Bhagavad Gita, or you find Mahabharata Santi Parava. The different way what a king should do. They said yes, a king has the primary responsibility of protecting his people. That's his duty. So our duty is dharma, and dharma is law. And then the practices, okay, whatever they have to do, they have to do it. And later they made it into a law. So if that is what is believed practices, they transmitted from one culture to another culture. But when you look at the law as essentially as a Western centric notion, then as a corresponding notion of duty and rights and duties, this is something essentially Western in notion. For example, we are primarily as a society which is duty bound. So if you look at read at Ramayana, if you look at Mahabharata, they're not asking about the rights. So Ram was not asking about Ram was not asking about the right. He's asking about my duty as a son. He was doing his duty as a husband to rescue his wife. He was doing his duty as a brother to support to support his brother. So we are primarily as a duty-bound society. So Sita is doing a duty as a wife. So we are primarily the duty-bound society, not a right to son. But Western society looked at is more often rights. So if our law is about more community-centric, the Western is more individual-centric. Now that you can discuss from cultural point of view. And that is why they said a cultural relativism. Each culture needs to look at its law from its own situation, from its own position. We cannot impose the law of one country over the another, or the norm, like culture of one country over another. For example, as an Indian, if I know the Westerner will look at me, and how did you have a arranged marriage? You did not know the bride. Your parent decided, and you still live happily ever after for 50 years, right? And we cannot sleep in 5 days. So this is because if I impose my ideology on them, or they impose their ideology on me, that would be chaos. So therefore, they said each culture, even the evolution of law, need to be understood in their own context rather than bringing a universality into that. And that is why they said the first set of law, the God is the source of all law. And the Old Testament has a very an idea, because what is called law, and what the God has given, what type of law they have self. They said if you are injured, then if you are there is injustice done, so you do the same other way. It's a principle called eye for an eye, which is a Latin statement said lex talionis, and in Latin it's called lex talionis, an eye for an eye. That if your brother has been killed, you kill his brother. So it's a law of revenge. The Old Testament says it's a law of revenge. And in fact, the one of the greatest saint of the time, Mohanty Karamchand Gandhi, says, if you follow the rule of eye for an eye, then whole world will be blind. So, but that was an early statement that God has given. That is why you have to do revenge. You have to do vengeance. That is why you have to take. If somebody has taken away your brother or father or mother, you have to take away from him that way. So that was the justice they said. But it is again an Old Testament. But when New Testament come, it was much more sublime. It was much more sober, and it talked about no. If somebody beat you, you turn the other cheek. If you check one side, which Gandhi used to follow, that if somebody give a slap with one cheek, you show the other one. Now it's talk about it's not about forbearance. It talks about creating a sense of proportion other person. It talks about appealing to the reason of other person. So first one is about experience. Second one is about reason. And then they develop 4th and 5th century. Talk about Greek law, which is highly sophisticated, especially in terms of writings of Plato.
No, sir. Yes, sir. What battery
If you are a
is
student
above
of
60%. No, sir. Battery is above 60%, sir. Okay.
So if you are a student of Greek philosophy, you will get to know that the one of the finest writers of Greek that time was Aristotle, who wrote 3 books, very powerful books, and one of them was state, one was on politics, and third was on law. Now he looked at this very sophisticated understanding of law. What is how it is be applicable to people, who will apply them, and what are the conditions of its applicability. That was the early history of that. Then we look at history again in terms about the crime, criminal acts. So which is called acts, crime against society. Then crime against the state. And then king at the land and the gods, because what gods will suggest. If you study a very beautiful book called the King Solomon's Diamond Mines, you read about, interestingly see about what they said. That is, if we have to take a decision, Solomon, this has to be based on what the God would say. And he would say, I have been advised by gods to do this way. There was a very interesting story where two women comes with one baby, and both claiming they are the mothers. The king tried all the possible efforts, evidences, asking to be lactation, asking to make the child sleep, asking to make them soothe. Nothing worked. And finally, exasperated, he says, as a king would believe, I order to asunder the child, to divide the child into two. So every one mother will have one of it. So the real mother cried. That's different story. But the idea is that how could he do that? Because he had the absolute authority to do that and said, I am doing on the eye of the God. So, I am following the dictate of the God. So these are certain things we do called development law. So then, and the Roman law talked about the dominant force of natural law. How this thing happening in the nature. And of course, first set of natural law is like might is right, jungle laws. So nature it happens. Those who are what Darwin would call the survival of the fittest, or the struggle for existence, are the essential issues of natural law. As we find the law of the water, the law of the fire, law of the forest. So we can see human society implementation of those laws. And then transforming those laws into what is called biblical canonical laws. So you find there are three different, like the civil laws, which talk about law for the state that the government is doing. Then the canon laws, the laws by the church. So they said we make a distinction between two set of law. In one set of law will be applicable by the king, because he will administer the people and the state. Other set of law will be taken over by the church, because they will discuss in the matters of religion and domesticity. So marriage, divorce, alimony, these are the church matters. Adoption, but police, army, prison, crime, these are the state laws. So these are defined elements. And then we find three elements. The law is look at legislative, look at administrative, look at judicial. So you will make law, you will administer law, and we will settle the dispute. So these are the three dimensions elements when law is required. Because first you say this is the law, then you say if this is law, you implement it, and third, you said if there is a conflict, then you settle it. So judicial dimension of it. That was the history. Now we look at the English justice system, which they developed, and US they established legal system, developed in the US system, and the Roman Senate starts, then emperor enforced by emperor and ruled by Roman courts. That's what called judges. The legislation, the administration, and the adjudication. So first law was passed by the Roman Senate. Senate passed it, emperor enforced it, and the courts manage when there is a conflict. So adjudicate over it. This is the system of law. That is, if we look at evolution of it. So Justinian Code is got, I'd say collection of all laws, 522 AD, 28 AD. Then the civil laws were enforced by the government and soldiers, but canon laws are enforced by the soldiers and the church, both way. Because without that is why in mid-century, the churches also used to have their army, because they want to enforce the law by the soldiers. If you don't follow the Pope, you don't follow the Father, you don't follow the Archbishop, so they would have the army to do so as well. Right? This is Justinian as second to equal justice, and the court, the institution like the students, the digest, and the casebook we are studying. So the code, the institutes, the text per law student, the digest for the case law book, trial decisions, because this all includes are the code. And then there is the codex, the statutes of principles, and the novels, the proposed laws. So these are some ancient notions, ideas when given. Then we find the law influenced European continent. So it has Roman Germanic law. Then Napoleon came and began Napoleonic Code. And then Constantinople's work, which called Laws of Islam, which is now called Sharia. Right. So the stems which come about differently, and different set of laws are prevalent. In England, we find that the common law, which after the Norman conquest, they decided there will not be a single law, but they will bring all together and make a uniform laws who is applicable to all the residents of England, all the residents of England. So it's a common law. It began a tradition of common law, common to all. Then become the civil laws, which are Roman Germanic. They will look at a law like we have in Goa. So it's a keep out the code, and this is civil law, which is to be decided by the state, and common laws by the judges. Then we have a socialistic countries. We talk about laws which are more focused on security or economic of people, and then religious laws like Sharia, which talk about belief and conduct. So these are certain things. And then as a development of common law happens, with the Danes conquered the northern France, and then the Normans conquest. So this led to history. And then developed by 1066, they developed in Anglo-Saxon law, and then kings enforced officers. Then they developed an accusator system, wherein person will be accused. Then the 12, what is called jury now, the 12 free men were appointed. They look at accusation, they look at the causes and discussed about all evidence are before them. And the 12 men, independent people, decide what would be the justice, what should be penalties. Now then, the Roman civil law was integrated with English traditions. So there was no distinction between the common law and Roman civil law. Then they put together and created a king's court, which talk about common law, which deals with criminal and civil matters. And then church courts, which church will deal with the canon law or biblical violations. Then canon law and civil law again come together, developed into common law by King Henry VIII, and judges become replace the sheriffs as court officials, and then judges made then law. So you will find judges try to interpret law, and judges will decide through the decision what should be the law. So that is what leads to call common law. That is why we call common law a judge-made law. Now, for example, you would get evidence of it, like in India. We do not have a law of tort per se. We have simple laws like Motor Vehicles Act, etc., etc. But as a tort law, we do not have. But mostly tort laws are developed by the courts. And what is decided? Because torts talks about the compensation. So we look at compensation depending upon the judges, are they decide what should be the ground of compensation and what should be the amount of compensation. And they are given the freedom to discuss an unliquidated damage. So when they are aware that the damage hasn't happened, so they can award damages. And once they do that, and there is no law for them. So we except certain labor law, except certain Motor Vehicle Insurance Act. So we do not have a now Consumer Protection Act. So we have largely uncodified. When you have not codified a law and judges are making decisions, that becomes a tradition of common law, and that is why we call it a judge-made law. Now, it is king's law and nobility a problem. The Magna Carta happens, then establish laws of England. Finally they got into constitution. Of course, their constitution is a unwritten constitution, but they have got this system in theirs. Now, it's 18th century become industrialized technology, and then look at America, and so there are different new types of law and the legal systems happen, which I don't want to discuss more because they will be too much for you. But you can look as continental at principles of common law and accepting that state and federal legal systems, and that is why it is still in fact common law existing, and it didn't interfere with the states and federal laws even to 90s, and then accepted practice by the courts, and then in America you find a federalism, United States, and federal legal system, which is not relevant to you. So I want to discuss many of them. But what is decisions like common law decision like doctrine of stare decisis, which means if previous court has taken a decision, we are not going to change frequently. To maintain the standard, maintain the consistency, we have to stand by the previous decision unless until it is very inappropriate or wrong in the eyes of law. And then which is now studied called case law, because that is become what is the case and how a case is developed. So look at different laws that is happened. Like I want now share with you. I will stop sharing this, but I will give an example to you in the context of Indian system. Then what happened in India and how we are examining the this Indian notion of the concept of law today. Because we as Indian and our laws primarily, as you said, are Hindu laws. So we have a Hindu tradition system. We had a system of panchayat, and many years ago, like in Chola Kingdom, if you look at history, they are the first time they established the courts, and they in those courts they established the people were the punchers, and the punchers were not, or what is now called who are people who are well versed in Niti Shastra, ethics. So it was not an ordinary person, because who king or anybody happy would give him. There were necessary qualifications were there. So they established qualification, their conduct in day-to-day life, and then they were appointed to settle disputes or become officers who can take decisions or judicial. And this is what they have in mind in the Indian tradition system. Then much later, it come to the village level. So if you look at the traditional Indian history, you will find even the king used to be guided to advisory boards, and they call it Sabha and Samiti. The Sabha and Samiti used to be give opinion to the king, and sometimes they used to even override the king's opinion. And that was what is the traditionally understanding, because they would know on the principles and what king should apply, and it is also applicable to king. In fact, in the Mughal time also, they used to have a consultation, but they were not overriding influence. But the consultation, because as Mughals came, so our traditional system crumpled, because you are not believing in traditional manusmriti. In which we have a Dayabhaga and Midakhara system, which Hindu laws talk about division of property, share of property, alliances, and etc. were decided. But when Mughals came, they brought about their Parsi laws, and then of course they brought about their the Sharia Islamic laws, and even they had this Devani Am and Devani Khas to discuss as a consultation. But their system of jurisprudence are much more looked into settlement of revenue disputes and the exemplary punishment in terms of criminal offences and so. So they try to impact some sort of Sharia, which was largely moderated because of the existence of Hindu laws and Hindu system. But however, as the Islamic rule become dominant, they replaced the Sanskrit and Parsi and Prakrit with with Arabic, Farsi, and Urdu as a court languages, and they continued for many years till Britishers came. And Britishers, once they came, they tried to put into their legal system in India. I would give one example of this. For many years in India, the land were primarily community, belong to ownership with the community. So it became a common property resources. Whoever wanted, if it was a land, is used by the community. Even kings do not infer that, but kings have the power to share them, power to give others as a personal loyalty. But those are largely, it is not individualistic. But the first time when Lord Cornwallis came and established the laws of Permanent Settlement Act in 1793, so it established the first set of that land belonged to the individual titles. So our patta became important for them. Forest, then they come in 1865, forest laws. So forest, which are common property resources till then, because kings had the ownership of forest, but people who are depending on forest for their fuel, fodder, food, so they were not prohibited from them. In fact, they were allowed to extract them. Only people who wanted to some roots, timbers, on medicinal plants, they might have to give a minor cess to the king because they were scarce commodities. But otherwise, there is no interference. The community, the forest usually belong to the people, belong to the king, and namesake for the king, but not to the people. But once the Britishers came, they wanted to look forest as the resources, and therefore the 1865 Forest Act primarily intended to bring it to the government control. So same way as the Britishers came and some of them become their interest to revenue collection. Therefore, they wanted to look into revenue collection records. So if you look at some writings like H.B. Halhed or this Macpherson, which talk about uh, which were interested to look at the land revenue system in India, so that they could know its nuances and establish a land revenue code for India as a mechanism of revenue collection. So that is part of their interest, was their interest in collecting land, collecting money from the sources, revenue from them. And second part of the same, when they established, they wanted, no, they cannot run the country only on basis of taking rent and revenue, but they wanted to also establish an order. So because they were coming from England, they had the Eurydice system in mind. So they tried to use laws which are now called as the colonial laws. So some of them were also beneficiary to India, including the 1923, 29, this Sati Prohibition Act. Like, so a lot of social legislation they also brought along with that, including establishment codes. So they have established their charters. So 1776, so they had charter, first charter, 1781, second charter. They established the charters, and which were essentially the British sovereign asking how the East India Company should rule India wherever the conflict were to do. Till 1856, when the first War of Independence happened, and directly our government, we become citizens from East India Company under to become British citizens. And in that case, so British Parliament enacted legislation and created privy councils to decide court cases from India. So this is how they established the legal system in India. And when the freedom movement began in 1935, they made Government of India Act, and they tried to consolidate everything, including the creation of municipalities, where some rule-making procedures, revenue collections were given to the municipalities till then. And even till then, 1935 Government of India Act become significant to even our own constitution, because many of our constitution derived a lot of from Government of India Act 1935. So if you look at the system of governance, system of administration, you will find evolution of that happen. And second, once our final evolution happened when we had adopted the Constitution of India in 1950. Once you have put a constitution, and then you remember that everything become constitutional, that it becomes the supreme law of land. So even courts have to work in accordance with the Constitution. And even if when the legislation make a law which is counterproductive to the Constitution, that become if it become unconstitutional, so they would say it is ultra-vires and it should be cancelled. So this is what is the constitutional supremacy, parliamentary supremacy. It happened, but not as a parliamentary supremacy as like Britain, but we have a parliamentary legislation, but we also followed the principle of separation of power, principle of rule of law, and established. And over the years, the courts have also tried to modify the different type of existence of laws and system of governance. And that is why, as a student of constitutional law, if you learn that many of these current legislations are a product of the way the courts have looked into issues of governance, issues of administration, and issues of rights of its citizenry. So if you look at the current act, the amendment in Article 21A, talking about the compulsory education, free and compulsory education to children, which was a constitutional mandate. The court has made, now it is time have come that we would make it a law. So government has made it a law in accordance with that. So by the way, the courts have expanded the open Article 21, bringing environment, health, education into its orbit, and thereby pushing a path where legislation has been forced to bring necessary amendments or legislation to fulfill the aspirations of aspirational India to modern India who can look at it. But simultaneously also courts have ensured that as a Lakshman Rekha exists, as a rule becomes the separation of power, they have not to encroach all areas. Rather, they had given a scope for the government that the policy issues are the government domains. But when the conflict comes, when executive failures comes there, so therefore you will find in many, it is not a very easy way to look at the evolution of law elsewhere, but we find the evolution of law has come from religion, philosophy, morality to politics, and from politics to rights, or rights to justice and equity. So primarily all societies, irrespective of their size, security, have always aspired to have what we call now a just, fair, reasonable, world order, equity world order. And this notion of equity and equality has become symbol as the objective of all human societies, and laws become a means to do that. And therefore, we remain always the aim of society is to have justice, and law is a means to that. And as societies, we continue to evolve, continue to dynamize, continue to develop, and like we develop, as Max Weber would say, that every society has its marked development. And if you want to look at the parameters of development, then you will find law as a parameters. So where this was at Durkheim said, the movement from mechanical solidarity to organic solidarity is also marked by the movement from repressive law to restitutive law. So even our look at criminal law system, we are becoming more restitutive, not even repression, not about eye for an eye, but a law which will take into consideration of the obligations, aspirations, values of people, and make them a better human being. So therefore, one parameter of development is a better law. A better society is that which have more established or better legal system. That is what I wanted to share with you, because Rahul would have known, because when we teach in the class, as a teacher, I will take in 1 hour class. So I think if it's 1 hour, then I'll automatically stop. That's why biological clock functions this way. And after teaching for 20 odd years, you would get to know that when to stop. But yes, I would not want to give you more examples. Maybe you might have some questions, some queries, and if time permits, we'll answer a few of them. And with this, I'll bring an end to my lecture today. But I would again thank Rahul and for giving me the opportunity to have a session with you, albeit online. So because they're difficult times, so it is again, this online is also an evolution pattern, and you find that evolution of online laws. Now, if you look at a lot of people working from home, and a lot of people working from home, what type of dress they wear? Like in class, I switch on my camera, then I find many students don't switch on the camera. So you find what is there. There is also privacy issues involved. If I ask my students, some officials, and at 12 o'clock at night, work from home, I called my client, who happened to be a woman, and she felt uncomfortable. So it will create online problems also. And look at evolution of laws that determining online activity. So that is why evolution is a continuous process. It's not going to stop, and it's only a way that we move forward. So that's it. I think that's a modern society. So it is evolution is a continuous process. It's the very nature of it, and therefore evolution of law is not a one topic. It's a continuity of it. Right. So that is it. Thank you very much. And now, if you have questions, I'll answer.
Yes, sir. There is a due to a network glitch. Yes, sir. The first question is that how to determine what law is?
Well, very simple question. What do they call as law? The primary question, if you look at what is legislated is law. For us, very simple. Listen. What is legislation? What is done by the legislation, that becomes a law. So there is no way to determine it. I'm not questioning the morality, but law is, as Ronald Black says, is a governmental social control. The mechanism of social control exercised by government is law. That's it.
Okay, sir. Now move towards the second question, sir. What are the aspects that distinguish eternal law from divine laws?
Well, divine laws are, simply as what is the charismatic thinkers like Buddha, the Jesus, or Muhammad had said about divine law. So it is about laws of the divine world, celestial world, what they believe it should be like. And human laws are the law as it is said by just now, what is called Austin, law made by the men for the men. So we will make a distinction. So human laws are laws which are made by men for men. Those are the laws made by gods or other people for the men. But this is for men by the men. That's the distinction.
Okay, so now the question is that, sir, how does the law is absolute? If yes, then how can we cope up with the changing exigencies of time, sir?
No, the thing you see, this everything is, as Einstein would say, is relative. This law is not also absolute, but every law, because law also changes. If it's absolute, it won't happen. Law also changes with the needs of the time. For instance, many years ago, we had a law in India which is called FERA, Foreign Exchange Regulation Act. But today we have a law, it's Foreign Exchange Management Act, because the globalization, industrialization, modernization, or liberalization required a new set of laws. So they are not absolute. Today we have a death penalty, we may not have death penalty 10 years after. So it is not, that is what the best thing, that is why it is evolving. It is not absolute. Right. But on the contrary, it's a many type divine laws are absolute. They are given. So you cannot change it. For example, like Sharia law. If you want to change it, they will say it is blasphemy. But the human laws can always subject to change, modification. Right.
So we are moving toward the last question, sir. As we all know, most of the laws in India are came from England or other countries. So is there any law, sir, which is itself evolved in India?
Yes. For example, there are many laws. One I am very fond of telling is Consumer Protection Act. So we have created from India itself. The other one is like we have a law which is no other country looks, but we look at it. It is called Preconception and Prenatal Diagnostic Techniques Act. So there are many laws which are evolved in India because that is the mark. In fact, you would be one way, because as you modified there is no distinction between Indian Criminal Code and the Singapore Criminal Code, because they have adopted as it is. But that was again coming from England. But we also have created many laws which are not come from other countries, but are one. These are two examples. But like we have even the Right to Information Act, it changes certain things. But it is I don't know.
Yes, sir.
Right.
So, yes, sir. So, thank you so much for giving us your time, sir, and knowledge, sir. It's a very nice and informative session for all the students, and it's also for us too.
Okay. Thank you very much. Have a good day.
Yes.
So,
So I'm really thankful you to on the behalf of the Geeta Ratan International Business School, sir.
okay.
Thank you for kindly attending our session.
Thank you. I'm leaving then. Yeah.
Yes, sir. Thank you so much, sir.